Welcome back to Things We Don't Talk About. This is the podcast where we examine the uncomfortable legal truths hiding behind accepted doctrine, precedent, and authority. Today we are talking about the Supreme Court cases that contradict one or another, how those contradictions affect our inalienable right, and how judicial decisions interact, sometimes violently, with the Constitution itself. So we're starting with Terry versus Ohio, a case most people don't realize fundamentally changed the meaning of the Fourth Amendment. Not through constitutional amendment, but through judicial exception.
So before we even touch on anything for Terry v. Ohio, we need to establish something that courts often gloss over, which would be that our inalienable rights, these are not granted by government. They are inalienable, which what that means is it's pre-existing government. So we think about often that the Constitution does, like people think about that it creates rights. No, the Constitution does not create rights. It recognizes and restrains government from infringing upon them. So with the Fourth Amendment, it clearly states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This shall not be violated. What it does not say, it doesn't say unless an officer feels suspicious. It does not say unless it's inconvenient. It doesn't say unless the Supreme Court creates an exemption. Originally, a seizure required probable cause and a search warrant and requirement of a search warrant. Terry versus Ohio changed that.
Which is a big deal because it led down a deeper rabbit hole, which we'll go down. But, like it said, it's not unless the officer feels suspicious. It's like, what's your articulable suspicion? What are your articulable facts? What crime have I committed? And if you can't come up with one, then you should be able to do some of these. So Terry versus Ohio, the exception has swallowed the rule. In Terry versus Ohio, the court held that the police may stop a person, detain them briefly, pat them down for weapons, based on reasonable suspicion, not probable cause. So this created two new legal concepts: investigatory detention, and then stop and frisk. So the court claimed this was a limited intrusion, but here's the problem: a stop is a seizure, and a frisk is a search. I mean, that is a fact. So,
darn too.
If I'm being detained and you're saying that that's a seizure, that's wrong because at that point, what is it? Is it kidnapping?
Right. So,
which is again a seizure. You're not allowed to go about life, and at a stop like a traffic stop, you don't have forever to conduct your traffic stop. You have to conduct it within a reasonable amount of time, and you can't, and you must let that person go. You can't just hold them on the side of the road forever.
And most people would agree that it's somewhere between like 10 and 15 minutes. Like I can understand, like, okay, maybe there is something wrong with the vehicle. Maybe the individual is traveling at excessive high rates of speed, or perhaps moving in and out of traffic. Like that's fine. And these would be a citation situation more often than not. But you can't just say, oh, well, because you were traveling at 90 miles an hour, I now have the right as an officer to detain you and bring out the drug sniffing dog and do all these other things. There has to be additional evidence to support that there would be a need for an escalation. Otherwise, yes, again, playing out this hypothetical scenario that a person is traveling at 90 miles an hour on the interstate and they're, traveling way too fast, then there's obviously a reason for a stop, but there's not necessarily a reason to detain things longer and move anything past that point.
And then searching cars and, bringing out the dogs. And that's a whole other, subject that we could get into. But Essentially, the court allowed both without probable cause. The investigatory detention and the stop and frisk. This was not a clarification of Fourth Amendment. It was a judicial rewrite.
So before we go too much further, I want to go over exact the word for word what is the Fourth Amendment to the United States Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So very, very specific things there, very specific things. Whereas, and the alternative, Terry v. Ohio gave much more broader exceptions, especially when you're talking about taking away the need for probable cause and the limiting of scopes of things. So looking at this, and basically the first question before we get into different Supreme Court cases and how they contradict Terry is that does this decision actually mean that the Fourth Amendment does not exist? I think if you asked a police officer, they would probably say yes. And I firmly believe that no, nothing has changed. The Fourth Amendment still exists. You still have to have probable cause to do all of these things. And we have kind of changed that through these different Supreme Court cases and decisions, like what Stephanie was just talking about, that instead of needing probable cause, I can just stop you. They even have a rule. They call us a Terry stop.
Yeah.
Well, but just like what she said, a stop is a seizure and a frisk is a search. So I don't really understand that. But here's some pretty interesting things about this. So this one, Brown versus Texas, which is out of 1979, this limits Terry. And the court ruled police cannot detain someone and demand identification without reasonable suspicion of criminal activity. So the implicitly contradicts Terry's broad discretion. If an officer can stop you but not compel cooperation, how then is the stop reasonable? That's a really good question. And that right there. So the court has definitely ruled that you must have reasonable articulable suspicion of criminal activity. Now, does that mean that rights violations still don't happen? No, they do happen. These decisions don't necessarily stop them from happening, but there's just really good to look at it and understand, hey, what does it mean? So one of the other things that I want to talk about before getting more and more into this is that when we're talking about constitutional law, we have to look at things very, very black and white, very cleanly. The primary reason for Terry v. Ohio, so I was just looking at this, I'll actually put the case up here. Sorry, it means just 1 second to get over here. So this was pretty interesting. So I didn't know that much about the case, but there was this detective who was just kind of hanging out in the 1960s in Cleveland. And he saw these people, these two guys kind of walking back and forth around the same shop over and over and over again, about 24 times altogether. And then every once in a while, they would go over and they would talk to a third gentleman. And you have two main people, and then you have this third gentleman who's over there, right? And basically what happened is that eventually there was a storefront. The police officer thought, given the amount of times they walked around the storefront, that they were eventually going to try and break into the store. It was late enough and didn't want that to happen. So the police officer eventually goes over there and introduces himself to these people and demands identification and things of that nature. And then he said he was going to pat them down. And this is where there was this overcoat, and he felt the butt of a revolver. And then because he felt that revolver, he places these people in detention and eventually arrests Terry. And this is where this case comes from. So one of the main issues that I don't even understand why this wasn't brought up in court is I thought Mr. Terry had the Second Amendment right to bear arms. And I don't understand how, because the charge that actually brought this up was Mr. Terry was convicted of possession of a firearm, which I thought you simply had the Second Amendment right to bear arms. Is that not the case, Stephanie?
Right. Yeah. Which again, like we just stated, rights are inalienable, so it comes before government. It comes from God himself. So
correct.
Yeah. So
absolutely.
Like, how can I even have that charge? on my record. It doesn't make a lick of sense.
Not really. So there's another court case. We'll move on from that. I agree with everything that Stephanie just said, but in contradiction, so Florida versus Royer, Terry stops can become illegal seizures. A Terry stop becomes unconstitutional when police exceed its narrow scope. This acknowledges something crucial. Terry stops are inherently dangerous to liberty, and they can be easily abused. So that's very interesting. Kind of touched on that earlier when we were talking about, hey, this police officer cannot just detain you indefinitely and say, hey, I'm going to wait 2 hours for the drug sniffing dog to get out here because I believe that there's drugs in the car. No, there has to be evidence to support things going past a certain point. So this is a very interesting case. Dunaway versus New York comes out of the late 1970s. Here the court ruled that detentions resembling arrest require probable cause, even if the officers label them as investigative. So I think this is hilarious because basically what that's saying is if a police officer says, I'm conducting an investigation, that police officer is basically saying, I have blanket authority to say, because I'm investigating, I can just keep you here for forever because I'm investigating. And what this court case is saying is, no, there has to actually be like criminal activity or a crime. You can't just simply detain someone or keep them or arrest them or not arrest them or something like you. There has to actually be some type of crime. And I don't know about you guys, but I see a lot of videos going around on TikTok and Instagram and other social media outlets where there is no crime whatsoever and people are absolutely detained and like things get escalated all the time. Maybe they need to be get more back on Dunaway versus New York here to understand that you can't just detain people indefinitely.
Yeah, absolutely.
God, that's funny. So this was kind of an expansion that conflicts with the original justification of Terry versus Ohio. This case is Arizona v. Johnson. The court. This was from 2009. The court allowed risks during traffic stops, even when the stop had nothing to do with a violent crime. This contradicts Terry's justifications, saying that officer safety would be involved. Now suspicion isn't even required to be crime related. That's actually a pretty big escalation, considering that the Fourth Amendment implications from Terry v. Ohio. Now we're basically saying that no, as this Arizona v. Johnson is more or less saying that, oh, because a cop exists, I can just simply pat you down or feel that something is unsafe or maybe something is this or that, but because I'm a cop, I can just do it. That's in my opinion, that's a very dangerous precedent to set.
Yeah, definitely a slippery slope.
Yeah.
Yep.
So
do whatever the fuck I want and get away with it cards.
Right. And again, I know we've talked about this a little bit again in this episode, but if I have the right to bear arms, then it really ends that I have the right to bear arms. I don't need to justify that. I don't need to, say anything. There's so many different examples I can give, but this one makes the most sense to me. And that, who cares if I have a weapon? I already have the right to bear arms. So now you're saying that because a police officer exists, I can just investigatory detention them. And then, because there's a possibility of a safety-related issue, there doesn't even have to be a violent crime reported or any evidence of, but I can just go ahead and pat you down and detain you and take your weapon and all these other things. And somehow, all of this that I just said is constitutional.
No. It's definitely statutory.
Yeah.
If I would say that, like, the only thing that could possibly stop your right to bear arms would be if you're on an honest felon. Like if you got that right taken away from you from the statutory kings and queens of the judicial system, then I'm sorry about that. But unfortunately, that is where that is. But like, if you haven't been convicted of a felony, why can't I, carry openly or concealed. It, it doesn't say in the amendment whether it has to be open. You have to openly carry.
Right. That's another point.
And just like always, you know, the amendments were written so feel like broadly, and then the judicial system has come in and pretty much just like regulate everything to the point where people can't move or breathe or anything. You just have to submit to what the statutory law wants, even though that's not even what
Right.
the Constitution wanted for us. It was supposed to limit the government's control on us, and the government has figured out a way to upend that. So so now we have over some regulation, and who the heck cares if it says that you have the right to bear arms.
Well, I mean, I think that definitely it's up to people to choose to either participate in taking care of their rights or not. I think it's up to each individual if it's something that you want to do. But I would say that it's very concerning to constantly see this stuff, and then again to go and to be on social media and to be part of the world and to see things. Like as an example, this is one that we were talking about the other day. So there's these guys. This is a video, something that happened, pretty recently. This is January 3rd, 2026. And there's these two guys walking around. They were open carrying their weapons. They were just walking around and open carrying. And out of kind of left field over here, two cops come up to them and they start talking to them about this. And the gentleman just goes, "Hold on, I have a question." Down there, you can see down there, probably 70 feet away, 50 feet away, that there is a police officer who has his rifle and he is at the ready to shoot these guys. Okay. And he keeps asking these other two cops, "Hey, why is this guy at the ready?" If you were in the military or anything, you should know what at the ready means. You understand what guns do. Okay. I don't think that needs to be explained. Basically what it is he's ready to shoot them. And one cop goes, "Oh, it's a safety thing." What do you mean it's a safety thing? Like, I don't understand. So like no one else has their weapon charged, ready, and pointing at anyone. So how can it be a safety thing for my rights for a police officer to be 50 feet away from me at the ready if I have the right to do something? So is that action justified because there's a duty to protect the public? I guess my response to that would be, in my opinion, anyone shooting in public is not protecting the public. So that person being ready to fire a bullet, which is not necessarily going to stop and could go through that person and hurt other people, that's not public safety.
Right. Absolutely.
So, and I get it, right? Like I understand that there are difficult jobs out there. I understand that being a police officer, you have to understand and adapt to the circumstances that are going on. I think starting at our constitutional rights is very simple. I think it's very simple to be calm and composed when going into situations. And then also understanding that if you're going into a very hectic situation, that it's easier to be prepared for something like that. So this stuff, in my opinion, is kind of crock.
Especially if you have an open carry, it's such a sensitive subject, and people will call you in. "Oh, this guy's got a gun on his hip,"
Right?
And then give him the bolo, and then all of a sudden you're being detained on the side of the road because you're openly carrying. It's like, well, either this is a benefit or a privilege, or it's a right. It cannot be both. You cannot regulate rights.
Oh, correct.
So, I mean, which one is it?
So this is very interesting too. So as we talked about a little earlier in the episode, sometimes the Supreme Court contradicts itself. So in this case, Hibble versus 6th Judicial District, this is out of 2004. There's a contradiction because it's compelling identification. The court ruled that states may require ID during Terry stops. But if we go back to Brown versus Texas, it says the opposite. So both are Supreme Court cases. Both claim to be constitutionally authoritative, and they both cannot be correct. So this is very concerning because we see in these decisions that now we're starting to contradict each other. And in the process of the contradiction, we're also using these cases stating that they supersede our constitutional rights, and they don't. They really just don't. Even though these decisions have been made and for years now they have existed, it's like a weird fugazi, guys. Like the Constitution still exists. I promise you it does. And like, it doesn't matter that these decisions have come down. They are not constitutional.
Yeah. And it is still the highest doctrine in the land. So until that changes, this is where some of these lawsuits come in, because it's like, whoa, guys, like you guys already decided on that. And then you decided something completely different.
Yeah.
So which one is it? Is it this or that? Is everything just circumstantial? Like, is that what truth and fairness is? Always a good question. The doctrinal problem is going to be reasonableness versus rights. So the Fourth Amendment was transformed from a rights-based rule into a balancing test. The court now asks, is this reasonable under the circumstances? So it must be by case, by circumstances, right? It just said that. But rights are not subject to convenience. They are limitations, not suggestions. Once reasonableness replaces probable cause, rights become flexible, conditional, dependent on officer discretion. That is the opposite of an inalienable right. Inalienable rights, like I said earlier, are not benefits and privileges.
No, those are very different things.
This is not getting the mail at your house.
Right.
So
it's not having like a food stamps program that you can go and apply to, and maybe you get food stamps or maybe you don't. Like, that's a benefit. That's not what we're talking about. So this is the real question that I don't think a lot of people want to ask. If the Supreme Court contradicts itself, and then also in the process or separately contradicts the Constitution, which one is Marbury v. Madison says the Constitution is the supreme law. For those of you who have watched us, we've touched on Marbury versus Madison several times. It is an incredibly important case. I think it's 1803. This has never been overturned. It has never been challenged. It stands as truth and everything. So this is not a constitutional interpretation. We're making judicial legislation here with these decisions. Okay. So when Terry v. Ohio came out and said that, we can just, for officer safety, reasonably do this, now we're going to have investigatory detentions, that's really the judicial system saying that they're going to create laws. And that has never been the purpose of the judicial system or the Supreme Court. They're there to interpret the laws and then deem, is this law constitutional? If that law is not constitutional, then nothing really comes of it. If it is constitutional, then that code or statute can be enforced.
And Mark and I, we sometimes go down these rabbit holes where it's like, well, they may sign these laws into effect, right? But like, who actually enforces these laws? Because if they're contradictory, then each person can have the discretion to enforce whichever law then puts them at that or their needs, or however they want to bend the law to their will. Now they have the discretion, because look at how many, just absolute constitutional challenges there are with the Supreme Court rulings that have been worked on. I mean, not all of them, but like there's a lot of controversy on a lot of cases where they conflict with each other. Mark and I are going to do some more podcasts about some conflicting cases in the future. It's really, really interesting. Hopefully you do too. If you want to hear about any specific cases, just leave a comment below, and make sure that you hit like, and make sure that so that way other people can find it and enjoy the content. But this these cases just touch like the tip of the iceberg of the contradict each other and how marketing. Before we started this, we were talking about who checks the judicial system, and what came up was the executive branch. Well, as you know, most courts are executive courts. So only Article 3 courts are actual judicial courts.
Yes, that's true.
So if the executive branch is the one who checks the judicial, but then there's executive courts, how does the executive branch check how does it check itself, And then we found out that only Congress can really appeal Supreme Court decisions, which we thought was very interesting because that is a whole other, so now I'm not even talking to my AG, Attorney General. I'm asking, people of America, or, however you want to say it, would then have to go to Congress. Congress, look at all these contradicting cases. Why aren't you appealing them? Why aren't you doing your job? Why aren't you looking into this? Why aren't you, why is there so many contradicting cases out there, I guess.
And from that too, is even when there's a contradictory case or any of these things, it's like, you guys, we still have to understand how do we go about enforcing things. So one of the things that I definitely noticed about modern day times is that we really are have kind of just set aside the Constitution. It's a tough thing to talk about. I don't like it. I don't like the fact that this is happening, but that's not relevant. And the reason that I can say this so conclusively is because of the conversation you had earlier. The conversation that Terry v. Ohio is used benchmark. Pennsylvania versus NIMS is another one. It's used every day across the United States over and over and over again to say officer safety, to say we can just go ahead and violate the amendment. And then we have police officers and people training them and legislatures and all these people reinforcing this because, guys, we're not changing anything. Okay, if anything, we're going further down the road of stating like that hey, we have people being arrested every day for charges that never become real. They're not real. So if I arrest someone, I'm seizing them. I'm taking them to a jail cell, to a district attorney, and the district attorney is coming back and saying there's no evidence to support a crime. Sure there is. It's called kidnapping. The police officer just kidnapped me. So how come every single time that we have a case dismissed, what we don't immediately see is charges filed against a police officer for kidnapping someone? How can I have a case dismissed? Why does that ever happen?
Yeah.
Well, how about this? How about there should not have been an arrest if there wasn't evidence to support probable cause to actually arrest that person?
Yeah. If you can't immediately in discovery show all of your evidence, then why even bring a complaint or an arrest to the forefront in the first place?
And don't have it be subjective, you know what I mean? Like if for a crime to have happened, there must be an injured party. So like absent an injured party, there is no crime. So absent me being able to face my accuser, there is no crime. Like these are the basic principles of due process that we're just kind of letting float away. Like and everyone's like, well, just take a plea deal, man. Just do this. You don't want to face worse charges. You don't want to do this. You want to.
Conflict of interest is another big one where it's like, well, if the state brings charges and the judge works with the state, how is that not just the biggest conflict of interest?
I don't. That's a great question. That's really great.
Who is my accuser? Who am I facing?
Yeah.
And
I think sometimes it's pretty easy to tell. I would say there's quite a lot of criminal complaints out there where it's like, yeah, we'll just as an example, truly as an example, Joe Smith went over to Kyle Williams' house and Joe beat the crap out of Kyle. Yeah, Kyle is the victim. This is pretty simple. You know what I mean? Like Joe is the perpetrator, Kyle is the victim. We can make this thing as long as
Yeah, but Kyle would bring his own charges.
No, the state
has to bring charges.
Right. So
which is where the conflict of interest comes in.
Yeah, depending on who it is, yeah.
Because the court works for the state.
Yeah.
If the state is appointed,
then we have to make sure that it's you can't have a situation like what Stephanie's saying is to prevent conflict of interest, you can't have the state be the complaining witness there.
There's a reason why jurors, you can't know the person on the stand. Conflict of interest, you cannot know that person. You're going to be excused from the case. Right? It's not an interview for everybody.
Right.
So, even Donald Trump, like there's been a judge that knew him or, gave donations to the Democratic Party, so therefore he had to dismiss himself from the case because he was prejudiced against Trump. So at the end of the day, there is just some funny things that happen with our judicial system. And, we're just here to, happy to, bullshit and, bring you guys along with us. So here's the question nobody wants to ask. If the Supreme Court actually contradicts itself and contradicts the Constitution, which one is supreme? Like we said, the Marbury versus Medicine. Technically, the Constitution would be the supreme law, but it never gets treated as superior, even though it should, because it's never been overturned or, any of that. So it still stands as affidavit and truth in law. Terry versus Ohio was just a case. It was a turning point in this country. It taught that government rights can be balanced away, exceptions can become rules, and liberty can be managed, not protected. As in, I can take your right and turn it into a privilege or a benefit. And when later cases contradict Terry, the solution isn't to resolve the Constitution. To restore the Constitution, it's stack or precedent on top of a broken foundation. Like we talked about all the other ones that came from Terry.
Yeah.
That's what we don't talk about, because once you admit the court can be wrong, you have to confront who actually holds power over your rights. Really standing on your rights, saying, "Hey, you are absolutely infringing upon me. Back off." And that's an uncomfortable conversation. Most people aren't ready to be like, these are my rights. Back off. People are usually like, okay, I'll comply. Here's my ID.
Whatever you want. I don't want to
want.
make this more complicated.
It's okay, I'll turn around and put my hands behind my back.
No, you officer with the gun, the taser, the backup, the body armor, you need to feel safe. That is important. It's not that as a citizen, my life matters. No, not at all. Yes, I'm leaning up thick, guys. Absolutely, being sarcastic here. So, no, there's a lot to uncover in all of this, and what I really think is the best thing to do for all of us is to go back to the basics, which is the U.S. Constitution, guys. It is inalienable rights. I know that people want to tell you it's differently. I know they want to tell you it's privileges. Yes, I have read the 15th Amendment. I certainly have. I'm very much aware of what it says. I don't care. I have rights. I don't have the privileges and immunities that are guaranteed me under color of law. That is not what we're talking about here in any way, shape, or form. And it is important for all of us to understand that we need to stand up for our rights. We need to have the force necessary to be able to stand up and fight for what you believe in.
Yeah, and not just let PACs and lobbyists just take those away just because they paid for it,
That's there, so they can pay for whatever they want.
God gave me these, and as
That's
as long as there's people out there who care, this is always going to be a topic. So thank you for joining us with things we don't talk about.
Thank you so much. I'm Mark Daniel Lemasti. It's been great seeing you. Can't wait to see you at the next episode. Okay, see you later, guys.
Bye, guys.